In this video, we're going to take a look at a couple of notables that have said XRP is not a security. Let's go.
And now, the Xrp Minute with Chip on the chain.
Chip here with the Xrp Minute. If it's your first time here, please like, subscribe, click that notification bell, and you'll be notified of new videos that drop. Also, check out on their other channel where we do live streams, only live streams, and have guests on, have a roundtable and all that. Now, let's dive headfirst into the shallow end for maximum impact. I want to go over here and take a look at this. This was an article that was posted on the IFTR site and basically makes the point that the former CFTC Chairman Chris Giancarlo and Conrad Balke of Wilkie, Farr, and Gallagher discussed Ripple and the application of U.S. securities law to XRP. Now, this is important for a lot of reasons. We're going to jump into it, but one of the things that we hear time and time again is the fact that Ripple is, with this new SEC versus Ripple lawsuit, alleging that it is indeed a security, when we've had a lot of people out there say it's not. None other than the Department of Justice, which we'll look a little bit deeper in later in this video. And also, you see regulators all over the world that have said, no, it's not a security. So, and also our, FinCEN, the regulatory body over here in the United States, also said it was not a security. So, and let's go through this article. So over the past decade, cryptocurrencies evolved from an anonymous white paper, that's none other than the Bitcoin white paper, circulated amongst a small group of cryptography enthusiasts, into several $100 billion industry. Prominent among the federal cryptocurrency regulators, the U.S. Securities and Exchange Commission, which we just mentioned. It's become active in the space in recent years, and has it ever. It became very active on December 23rd when they filed a complaint against Ripple Labs. And there was a flood of retail investors into the cryptocurrency markets, and proliferation of initial coin offerings, better known as ICOs, have prompted concerns of fraud, market manipulation, and lack of prudential oversight. And again, one of the companies in the forefront looking for that sort of guidance and oversight was Ripple. While other agencies have asserted overlapping jurisdictional claims, the SEC has taken the position that some cryptocurrencies are securities and thus fall within the regulatory purview. However, the SEC has prudently recognized that the application of the securities laws to cryptocurrencies may not be warranted in every instance. Senior SEC officials have made public statements that Bitcoin and Ether, two of the largest cryptocurrencies by market capitalization, are not securities. Now, this was published back in May of 2020, just so you know, for some relevance reasons. Although it would be unreasonable to expect the SEC to weigh in on each of the over 5,500 cryptocurrencies in circulation, noticeably absent from the agency's comments on the regulatory status of Bitcoin and Ether is any mention of XRP, the third largest cryptocurrency. Now, back when this was issued and released back in, I think it was May of 2020, they're bringing up a very good point, like why over 2+ years was there guidance for Bitcoin and Ether, but nothing for XRP, which by market cap has been number 3, and it's also eclipsed. It's had its moments where it's gotten up there. So they go on to describe, much like Bitcoin and Ether, XRP is a digital currency supported by a distributed ledger, which uses cryptography to store and transfer assets. However, XRP and the underlying XRP ledger were designed in 2011 and 2012 specifically as a payment mechanism by software developers who later founded Ripple Labs. Now, I think this is key and important point to recognize, because the SEC complaint is alleging that Ripple didn't have any use case when clearly the ledger was created for that very use case. So I think they're going to have a hard time having that argument stand up in court. Today, Ripple uses XRP to address liquidity challenges faced by financial institutions, including high transaction fees, long processing times, and the need for third-party monitoring, interposed by traditional clearinghouses and settlement mechanisms. Now, here what they're pulling out here is the fact that, yeah, not only was their use case, but they were addressing some of the shortcomings of maybe, you look at the gas fees on transferring Ether, you look at Bitcoin, the time it takes. So they're sort of laying the groundwork here. And what they say sets XRP apart from its peers is the XRP ledger. And unlike the blockchain protocols that support many other popular cryptocurrencies, The XRP ledger does not reward network participants for validating transaction on the ledger with coins, process known as mining. And of course, this is what Bitcoin and Ether, and now Ether's switching over out of that, for Bitcoin, or if I should say for Ether 2.0. So in the absence of mining, XRP cannot be generated by third parties. Instead, a finite supply, where 100 billion were created at the time of inception. Slightly more than 50% were currently held in escrow by Ripple and sold periodically. While these differences enable XRP to better serve its intended purpose as a liquidity tool and settlement mechanism, they do not fundamentally set XRP apart from its peers from a legal and regulatory perspective. And let me say that again, because I think this is really key. They do not fundamentally set XRP aside from a legal and regulatory perspective, right? Now, this goes totally against the grain of what we saw in the SEC v. Ripple complaint. So investment, and one of the things that's alleged in the SEC complaint against Ripple, that XRP is an investment contract. But look what we see here. No, XRP is not an investment contract. SEC's taken the position that certain cryptos are investment contracts within the definition of a security. And then they tie this back to the Securities Act of 93 and the Howey test that happened in 1946. And the Supreme Court basically held that the investment contract exists where there's a contract, a transaction or scheme whereby a person invests his money or her money in a common enterprise and is led to expect profits solely from the efforts of the promoter. Now, in this case, Ripple has no control over XRP whatsoever, right? Ripple doesn't have anything to do with the price of XRP, and there is no investment contract. But that's not what the allegation of SEC v. Ripple is all about. SEC issued guidance building upon the Howey framework, known as the Howey test, in the context of digital assets. For example, assets that are issued and transferred using a distributed ledger or blockchain technology, including but not limited to cryptocurrencies. Now, how we got from Mr. Howey looking to expand his orange groves up in the middle of Florida in 1946, when the SEC brought the house down on him, to trying to tie the Howey test to, some of the basic underlying principles, but again, it's a very big stretch to then tie in digital currencies. So they were citing certain factors the agency would consider in determining whether or not there was a common enterprise and a reasonable expectation of profits derived from the efforts of others. Even if XRP were to satisfy one or two prongs of the Howey test, it does not satisfy all factors such that XRP is an investment contract subject to regulation as a security. And this is it. This is the whole argument. The fact is even if it hit one of the prongs, and even one of the dissenters, Frankenfurter was one of the justices in the Supreme Court, and he actually wrote the dissent on the I think it was a 8-1 decision, and basically said that he didn't believe there was a violation, only because even though you bought a plot of land and you didn't have to farm it and you didn't have to take the oranges to market and you could earn a profit from it, one of the things that Howey said was, no, it's your land. You come in, you can do whatever you want, you can inspect it. So his dissent, they looked at this and said, no, you could actually, it doesn't satisfy the idea of a security, because some people may have chosen to actually go ahead and take the land or work it or find a way or actually visit it or whatever, and they could inspect the parcel prior to purchase. So that was a key thing in the dissent, and I also think that what they're talking about, these prongs, even if it does meet one of them, there was no investment contract. People didn't think they were buying a share of Ripple. Ripple is a private company that has its own private shareholders. So there's no investment of money. The first prong of the Howey test, which is an investment of money, has received little attention. It's unfortunate because it has a particular relevance. The Supreme Court chose the specific word investment over alternatives such as expenditure. Now, while one could argue that there are many outlays of money that constitute an investment, the common understanding of the term investment is the transfer of something of value in exchange for a future return, rather than a present one. Yet, XRP cannot be an investment contract, as there is no contract or arrangement to speak of between Ripple and the overwhelming majority of XRP holders. To the contrary, the contracts that Ripple has entered into explicitly exclude general XRP holders as third-party beneficiaries. This brilliantly lays out the case why XRP is not a security. And while the Supreme Court never held that an investment contract requires a formal agreement, Case law and the economic reality of these transactions do not support the assertion that there is somehow a contractual or other relationship between Ripple and members of the general public that acquire XRP on the secondary market. But this is contrary to what the SEC v. Ripple complaint is all about. They're hedging everything on the fact that there was. And I think this will be easily proven in court. The mere fact that an individual holds XRP does not create any relationship, rights, privileges with respect to Ripple any more than owning Ether would create a contract with the Ethereum Foundation, the organization that oversees the Ethereum architecture. However, even if a relationship were to exist between XRP holders and Ripple, and the purchase of XRP were to constitute an investment, XRP still cannot be considered an investment contract, as it does not satisfy the remaining prongs of the Howey test. So they're even saying, like, even if there was one or two of the prongs of the Howey test, there's no way that it can satisfy all of them. They talk about the fact that there's no common enterprise. In determining whether there's a common enterprise under the Howey test, the federal courts have required there to be horizontal or vertical commonality between the parties. Horizontal commonality focuses on the relationship between investors in an economic venture. Courts have found such commonality where there is a tying of each individual investor's fortunes to the fortune of the other investors through the pooling of assets, usually combined with the pro rata distribution of profit. No horizontal commonality exists with respect to XRP. Now here we go again. They're really pointing out the fact that it doesn't meet that prong of the test. Further, as discussed above, as we previously discussed, ownership of XRP does not purport to give any holder rights with respect to Ripple, and a holder of XRP is not entitled to share in the profits and losses of Ripple. And again, this is one of the key allegations made in the complaint, the SEC v. Ripple, better known as the Securities and Exchange Commission. But one of the things they're asserting is the fact that maybe somebody might have thought they were investing in Ripple. Nobody ever thought they were investing in Ripple or share or had any entitlement to any of the profits that Ripple, the company, would have. And to even believe, and I think it's preposterous to even believe that Ripple had any bearing, which is some other things in the complaint, that Ripple had any bearing to this to the actual price of XRP. They certainly didn't control it, regardless of the $1 billion they released from escrow to go ahead and sell on the open market, usually to institutional investors. So I'm going to go through this here. So no reasonable expectation of profits were derived from the efforts of Ripple. The third and fourth prongs of the Howey test, which is a reasonable expectation of profits derived from the efforts of others, are also absent given the fact that Ripple's marketing forbearance and the autonomy of the XRP architecture, right? Because the marketing forbearance and the autonomy of XRP, completely a separated thing. You've got what happens on the ledger, which is decentralized. You have XRP, a decentralized currency, and tying back to Ripple, which is a centralized corporation that operates out of San Francisco in the United States, right? They're two separate things. Ripple has not marked XRP as an investment product, nor has it promised XRP holders any sort of profit in return for its investment. And this is one of the key principles or prongs, as we're calling it, in the Howey test, is that the people who bought a parcel of land, there was a direct expectation that they would go ahead and receive some potential profit in the future and they wouldn't even have to do anything if they didn't want. If they didn't want to go ahead and take and farm the land or take the oranges to market to be able to earn to some sort of a profit. And this is what the key distinction they're making. To the contrary, Ripple has repeatedly emphasized the functionality of XRP as a liquidity tool and a settlement mechanism. The fact that certain parties may acquire XRP with the hope that it may appreciate in value cannot be dispositive as the same is equally true of a large number of Bitcoin and Ether speculators. Now, we also know that the SEC has come out publicly and made statements that Bitcoin is not a security and nor is Ether. But if you start tying some of these basic principles, which I like what they're doing in this article here, that Giancarlo is making here, is the fact that if you're gonna say that Ether is not a security, but then you're talking about some of the same principles and guidance that happens with XRP, you're gonna get into, so how can it be okay in this case and not okay in the other case? So in a non-binding guidance aimed primarily at ICOs, initial coin offerings, the SEC suggested that the two main areas of focus when determining whether there is reliance on the efforts of others are the expectations of the investor and whether the efforts of the promoter are essential managerial efforts which affect the failure or success of the enterprise. With respect to XRP, purchasers cannot reasonably rely on the efforts of Ripple, as the XRP architecture is fully autonomous and exists entirely independent of Ripple. Now, we also know that David Schwartz, who's the chief tech officer, has come out and said, and as Brad Garlinghouse has said, hey, one of the key principles of XRP is that Ripple, the company, gets deep six tomorrow, meaning they no longer exist. Guess what happens to XRP? Nothing. It will continue to go on. Anybody can pick it up and run with it, right? And start working with the XRP ledger. Now, that's one of the key principles because that kind of goes against everything in the SEC v. Ripple complaint. It says right here, Ripple would cease involvement in XRP entirely. XRP ledger would still function through third parties, and that's going to be a tough one for the SEC to overcome as well. So there's multiple avenues to be able to pick this apart. That's why we saw Brad Garlinghouse and Chris Larson come out and be and not want to settle personally because they know they got this one, and they certainly have. Given what the precursors that have existed before with the with the Department of Justice, with FinCEN, and a bunch of other organizations that have come out and said it's not, right? So I want to move a little bit beyond the Howey test and talk about the fact that XRP is sufficiently decentralized to avoid regulation as a security. Now, the validators and the nodes that are run, there was a time when Ripple did have more nodes and could control it, but there was recently a rule passed on the that the Ripple validator voted against, right? But it doesn't have carte blanche. It cannot say that, hey, we're Ripple, we don't like this rule change. And I don't recall what the rule change was right now, but they put stuff up to be voted on by the validators, and it got passed. Why? Because Ripple, I think there's 17% or less that they actually have impact, which, if it's not more than 50%, they don't have the majority stake, which means that it's decentralized. They have a say, but their say it can be overridden by the rest of the nodes. So this is another key thing as well, the fact that you have centralized company, decentralized asset. And the SEC Division of Corporate Finance Director William Hinman opined that a digital asset status as a security may be subject to change over time if the network on which the token or coin is the function becomes sufficiently decentralized, a sentiment reflected in the subsequently released digital asset guidance. So this is what we just talked about, the fact that it is, and it has happened over time. There was a time where, Ripple could have all the impact, but not anymore. Now, while decentralization is an inherently difficult concept to quantify, Director Hinman cited a number of factors that the SEC may consider in making this determination, including several analogous to the Howey elements already discussed above. This is the problem when you go back to the 1946 law, right? I'm not going to get into some of the stuff that Hinman had said about this. So basically, let's jump into the fact that the utility token was used for liquidity, right? So in recent years, SEC began to explore the concept of utility tokens, digital assets that represent a right to a product or service offered by the issuer. In certain circumstances, agencies taken a view that the utility tokens do not represent an investment contract and has allowed ICOs of utility tokens to proceed without registration under the Securities Act. But what is an initial coin offering? Why would a company go ahead and put out their initial coin offering hoping to open at a certain value? Well, when that happens, it's pretty obvious what goes on. They're hoping that they're going to go ahead and raise money, right? But a lot of this hinges on the fact that they reached out to the SEC and got some guidance prior to doing that. Now we know with Kick and the Kin token that didn't happen. They just went crazy bananas and started, doing it, and then they got in trouble. So that'll happen too. Where in this case here, we have a scenario where, David Schwartz has come out and said, look, we've been reaching out saying we're doing this, we're doing that, fully transparent. They're one of the most transparent companies in the blockchain crypto space, and yet they're getting hammered for this. But it's a good thing, actually, how it turns out. But it's a long article, guys. So if it's not a security, then what is it? So ultimately, under a fair application of the Howey test and the SEC's presently expanding analysis, XRP should not be regulated regulated as a security, but instead considered a currency or a medium exchange. And that's what we're going to talk about, the fact that we have the former chairman, Giancarlo here, saying of the CFTC, which stands for the Commodity Futures and Trading Commission, saying, no, it's not a security. And there's a lot of other things that they go on to say here, but what I wanted to jump into next is another important document. This is the Department of Justice. So when you start worried about that, like, oh my gosh, what's going to happen? I'm worried about this. And suppose you don't even live in the United States, but you're also worried about your investment. I think this might help put your mind a little bit at ease, just looking at all the firepower Ripple has. I'm not an investment advisor. This is not investment advice. This is just Chip giving his opinion. But something to consider here. I wanted to look at this one tweet here. This tweet was given to me by Jerry and Frecky, and that's at MaxXRPBTC, and was sending me a tweet by Paul Esper. And I went out and grabbed the document. This is from the Justice Department, which is the DOJ, Department of Justice. Paul Esper said, hey, I found an interesting publication from the DOJ acknowledging again that XRP is as a currency. And this was published just, I think, in October, if I'm not mistaken. I'll jump in, but it's nice that he went and highlighted it. So we're going to look at the highlighted one, but I did go ahead and find it here. If you want, the link is in the description below if you want to go peruse it and check it out and look at it, look through it. But let's take a look at this. So in just one example, and again, this is the Department of Justice, and one example of a successful collaboration, FinCEN, working in coordination with the U.S. Attorney's Office for the Northern District of California, assessed a $700,000 civil monetary penalty in 2015 against Ripple Labs and its wholly owned subsidiary, Xrp2 LLC. And Ripple Labs, which is headquarters in San Francisco, facilitated transfers of virtual assets and provided virtual asset exchange transaction services. The company also operated a virtual currency known as XRP that in 2015 was the second largest cryptocurrency by market capitalization after Bitcoin. And they're catching it at that moment where it was the second biggest one, right? And then obviously Ether overtook it, but they've kind of, when the price rises, don't know the exact amount based on how much is held, it wouldn't take much for a price rise for it to become number two again, although overcoming Bitcoin would take some doing. And what they're saying here is that by parallel investigations by the Department of Justice, otherwise known as the DOJ, and FinCEN found that Ripple Labs willfully violated several requirements of the BSA by acting as an MSB and selling XRP without registering with FinCEN, and by failing to implement and maintain adequate anti-money laundering program. Ripple Labs entered into a settlement agreement that resolved the possible criminal charges and required the entity to forfeit $450,000. These funds were accredited to partially satisfy that $700,000 civil money penalty. In addition, the settlement agreement required Ripple Labs to engage in steps to ensure future compliance with AML, anti-money laundering, and CFT obligations, which they did. Okay, so they did get in a little bit of trouble. They made a little sidestep, but guess what? It was quickly corrected. And again, they're looking at this as a currency. They have been all along. FinCEN's been looking at their records ever since this ruling and going through audits and inside of full compliance. Now, let's look at this other one here. All right, here we go. So instead of the exchange of value, in particular virtual currency, generally is based on an agreement of trust among its community of users. Virtual currency can be convertible, meaning it has an equivalent value in real currency, or acts as a substitute for real currency, or non-convertible, meaning it's specific to a particular virtual domain, such as an online gaming community, and cannot be exchanged for real currency. Cryptocurrency refers to a specific type of virtual currency with key characteristics. The vast majority of cryptocurrencies are decentralized, and they lack a central administrator to issue currency and maintain payment ledgers. In other words, there's no central bank. Instead, cryptocurrencies rely on a complex algorithms, distributed ledgers, which are referred to as the blockchain, and a network of peer-to-peer users that maintain an accurate system of payments and receipts. And as the name suggests, cryptocurrencies rely on cryptography for security. Some examples of cryptocurrencies include Bitcoin, Litecoin, and Ether. Now, cryptocurrency can be exchanged directly person to person through a cryptocurrency exchange or through other intermediaries. The storage of cryptocurrency is typically associated with an individual wallet. And I'm not going to go through this whole thing. You kind of get where it's going, but you see that what they're referring to this as is not nothing like a security. They're talking about it as a medium of exchange, as a cryptocurrency, and they're tying that up pretty well. And so the Commodity and Futures Trading Commission is an independent agency of the U.S. government. It was created in 1974. It regulates the U.S. derivatives market, which includes futures, swaps, and certain kinds of options. So they certainly, the article we looked at with Giancarlo certainly has some, I think, has some very strong points that were provided in there. And when we're looking deeper into this, I hope this puts you a little bit at ease. Now, anything can happen in the realm of possibilities. Anytime you go to court, you can say there's no such thing as a slam dunk. But I believe in this, with this complaint in the SEC and with the strong voices, the fact that DOJ said it was a currency, the fact that we have the CFTC former chairman saying, no, it's not a security, making all the right reasons for it, that it doesn't hit the prongs of the Howey test, all three of them. And of course, that doesn't really bode well for what's happening inside of the cryptocurrency market. Nobody anticipated cryptocurrencies back in 1946. And it also goes further to show that other countries have adopted regulations. We have the Europeans are moving forward. We have the United Kingdom, we have Australia, and Japan leading the way. So in my opinion, I believe that this is going to be, there's a lot of powerhouse, and Ripple has some of the best people, not only their attorney team, but they cannot wait to get and fight this thing. How long will it take? Well, no, it takes as long as it takes. But the fact that Brian Brooks, the comptroller of the OCC, coming out just a few weeks ago saying that we will have crypto regulations in as little as 4 to 6 weeks. So that's been in the works for some time. I expect this thing to go to bed pretty quicker versus later. I don't think this is going to drag out to a year or 2 years. And we're also going to get some other, I would say, other clarity that's going to be coming. So when we think about the clarity that's coming, this is all going to wrap up well. If it's your first time here, please like, subscribe, click that notification bell. You'll be notified of other things we do. Also, we're live streaming on our other channel. Click that below. Go over there. If you're not aware of that channel as well, we do live streams. You click that notification bell as well, and you'll be notified. And we usually do 3 live streams a week, but we've ramped it up because there's so much energy and so many questions coming in about this SEC v. Ripple, and we want to go ahead and address them. That's all I have for now. This is Chip, and I will see you on the next one.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.